Well, imagine if you had your own personal lawyer available to answer questions for you free of charge. That's what you have here on a Thursday morning on Radio 97. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us each and every Thursday morning to offer her legal expertise by providing some general advice on the latest hot topics. She has experience that spans more than a quarter of a century in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. Despina with us once again this morning.
Good morning, Wayne. Good morning, Brooke.
Good morning, Desi. Good morning, Wayne. Alrighty, kicking off this morning, we're talking about buying off the plan. What happens if you don't settle on settlement date? We've spoken about this before, but we wanted to kick off with starting with just this general question, Despina. Do you think developers are fairly sympathetic, in your expert opinion?
Ooh.
Absolutely not.
Didn't think so. Why do you think that?
Well, why do I think that? I mean, at the end of the day, a breach of contract is a breach of contract. And we're talking about potential breaches in any contract, but particularly with off the plan, meaning you get to the end of the completion date, you've waited all these years for a project to be finished. And if you can't settle on that settlement date, the developer and incurring those risks and incurring all those costs in getting that project complete is naturally going to be unsympathetic to a buyer who says at the end of the day, I can't complete. Now, I'm not saying all of them are like that, but of course, that's commonly you'll see developers not being sympathetic to requests for extensions, give me more time to settle. They're generally not. And the reason I say that is to make the stark, harsh reality to buyers in that there is a risk in going into any contract. There's risks in going to an off the plan, and you need to understand those risks before you go into a contract and understand with an off the plan, you are in for the long haul. As I say to buyers, once you get past your cooling off period, you're locked in, Eddie, as I say, right till the end of that period, which is whatever sunset date is in that contract. You have to wait for that journey to be completed, for the project to be completed, and you've got to settle on the settlement date.
And how many years are we talking about? What's the general length of that time period there?
So in Queensland, we still have a maximum sunset date period that's allowed of 5.5 years. So yes, typically developers, depending on the type of project, we said this before, whether it's a smaller project, whether it's a townhouse or whether it's a high rise, will dictate the sunset period. Generally, a high rise will give you a longer sunset date period because they need longer time to construct, as opposed to a land subdivision or a townhouse project that's quite small. So typically you might see 2.5 years or 3.5 years for a smaller project. Yeah.
Okay. So, and you're talking about high rises there. So there was one case that you sent us that is pretty phenomenal. It is a bit infamous. The Soul Penthouse on the Gold Coast. What happened there? I think it's a perfect example of what we're talking about.
Yeah, so people might remember, and it's a really good case to actually bring to light again, but people might remember what happened back in 2015, 2016. So people will know the Soul building, and that was built in Surfers Paradise, and the Juniper Property Group built that. Now, they started to market and sell apartments in 2006. 2007, a particular gentleman by the name of Mr. Caltabiano entered into a contract of sale to buy the penthouse in Seoul. Now, the penthouse at that time, the purchase price for that penthouse in 2007, I'm harping on the years here because it'll become apparent soon with the years as to what happened in the market. So in 2007, the purchase price was $16.85 million.
Yep.
A lot of money.
Yeah, we're talking big bucks. Yeah. So 2007. Now, the project was completed in 2012. So if we think about what was happening in the market then, 2007, 2012, we had a GFC in between there. I think the GFC was 2011, 2012, and that obviously had a massive effect on the market values. Now, notwithstanding any of that, of course, the buyer under his contract was compelled to complete on the settlement date, like I said before. Now, he couldn't do that, and he asked for numerous extensions, and the developer, in this case, granted numerous extensions. So if you think about that and why Juniper did that, I mean, I can't speak for Juniper at the time, the developer, but in that market, the market would not have been buoyant. The market would have dropped because of the GFC. So I dare say, of course, in that particular circumstance, the developer's hoping and would give an extension, yes, to go, oh, look, I'll give an extension, keep doing that because I want him to settle on this very high price for the penthouse. In a buoyant market, I dare say that may not have happened because the developer would have gone, oh, it's not worth 16.85. It might have been worth 20 million.
Yep. So I'll take your money, thank you, and sell it again. Yeah.
Well, that's right. So the long story short of this is that after numerous extensions being granted, 2 years later, the developer decided, you know what, I've had enough. I'm just going to terminate the contract, which was his right to do so. And he terminated and took the entire 10% deposit. But not only did he do that, he also then sued the buyer for breach of contract, and he won in the end. So this was a very nasty tale for the buyer. But I guess at the end of the day, the moral of the story is you do need to understand that developer has rights. If you can't settle on the settlement date, you will be in breach. And the clear right that the developer has is if you are in breach and you cannot settle on the settlement date, your deposit will be forfeited, meaning the developer can take your entire deposit and take that money, and then he has other rights against you as well.
So how much in total did the buyer end up having to pay? Because he had to pay the 1 point something mil deposit and then the damages after that.
Well, the deposit he paid early on when he signed the contract was lost. So that was 10% of 16.85 million. But then the actual court order, so the developer was awarded over $14 million in damages. So the buyer was ordered to pay that in damages. So you've got the deposit, you've got interest, you've got default interest, you've got costs, legal fees, and of course damages because the developer was entitled to that money and the buyer failed to settle. So very harsh reality for that particular buyer.
And of course, we're talking here about very large sums of money. This is a pretty unusual case in itself. But when you scale it down to every day off the plan, developments, it's the principle's the same.
It doesn't matter whether it's a small scale. So if you're signing a $500,000 off the plan contract for an apartment or whatever the issue is, or for a land, or whether you're signing a contract for a $20 million property, the principles are the same. If you cannot settle on the settlement date, then the developer will be able to terminate that contract, will be able to take your deposit, and will be able to sue you for damages. And in a market that is in a downturn market at the time settlement's due, he can sue you for a deficiency on selling that property, because he's got to have to sell that to somebody else to obviously get some profit. And any deficiency in a price, he can sue you for that deficiency in the price that he was going to get, but now he can't because you couldn't settle and he's got to on-sell and it might be a lesser purchase price. So all sorts of nasty things. I call them very nasty things when I talk to buyers. And we talk about the time leading up to completion, what you have to do as a buyer, getting all your ducks lined up in a row. Because I'll say again what we started with, and that is developers are unsympathetic, right, to buyers who are in default. In this particular case with Juniper, the interesting part was that you see Juniper went under at that time as well. So the receivers and managers for Juniper came in, took over the project, and then managed all these contracts. So, of course, developers are not sympathetic, but neither are receivers and managers. They just want their money. So you've got to be prepared to go the long haul and settle on that settlement date. And in this particular case, this buyer was a bit of a speculative buyer, it came out in the court. So he actually never had any real intention of settling. He was trying to make a profit and on-sell to another buyer. And that's actually a very risky game to play, because where the market is, when you sign your contract, you don't know what the market's going to look like when you have to settle.
No, well, 5 years down the track, it can change dramatically, can't it?
Absolutely, yes.
Yep. All right, so it sounds like the lesson there, you just mentioned nasty things. So the lesson is look out for those nasty things.
Well, yeah, the moral of the story is to understand what you're getting yourself into and to be prepared to take those risks. And of course, yes, developers are not sympathetic to your particular needs, whatever they may be at the time, if you can't settle. So you've got to be prepared for that.
It's a cutthroat world, Despina. And coming up next, new land tax laws are coming to place in Queensland on the 1st of Jan. The government is up to something, Desi. Is it positive? Is it negative? Despina has all the details coming up on Talking Law in just a moment. Stay tuned.